Good afternoon, everyone. Welcome back to Business Law 1. Today we're going to be looking at Chapter 32, which involves intellectual property. The overall learning objectives for this chapter, I want us to first understand the different types or kinds of intellectual property that are available under U.S. law. I want us to understand the difference between patents and trade secrets and why a company might choose to develop a product or service as a trade secret as opposed to a patent. I want us to be able to distinguish what copyrights are from trademarks. Both are intellectual property, but they serve and act in different functional ways. And then at the very end, understand why some marks may not be eligible for trademark protection. So that's the overall focus for this particular chapter. Anyway, when we talk about intellectual property in just a general sense, this is a new and growing area of the law. It's intangible property that a business or an individual might own, and it represents a huge asset for a lot of companies. So, when we look at, some of the major, corporations that exist in the United States, as well as globally, we'll see that they have a huge amount of intellectual property in their portfolio of assets. And so when we talk about intellectual property, regardless if it's a patent, if it's a trade secret, if it's a copyright, if it's a trademark, all of these types of property are licensable. If you don't want to actually develop a product, but you have a patent, you could license it and permit other people to make your product for you. And then they pay you as per whatever the agreement is. If it's a trademark, if it's a copyright, same thing, you can license it, you can sell it. There's so many different ways in which you can deal with this type of property, just as if you were dealing with a piece of real property. And so it represents a huge asset for a lot of companies, and we'll talk more about that in a little bit. But it's a huge, massively growing area for business activity across the United States and the world. So I usually start off talking about trademarks because that's usually what most people are familiar with. And so when we talk about a trademark, or we could be talking about a service mark, if you see the phrase service mark, that's exclusively regarding a service. So let's say Sprint Wireless. The wireless service is technically, Sprint has a trademark in all the different logos and slogans that they've come up with for their wireless communications network. But it's also a service mark. So service mark and trademark can be used interchangeably, and sometimes I think that throws students off. But trademarks can apply to anything, product or service, although service is just a service mark. So just kind of to get some of the jargon down. Anyway, in the United States, there is federal legislation called the Lanham Act, and this is the federal law that dictates and guides, trademarks that are registered through the national government, the U.S. Patent and Trademark Office. And so anything and everything about trademarks on the national level is going to be through the Lanham Act. Under federal law, when we talk about intellectual property, so we'll talk about patents, copyrights, and trademarks. Trademark law provides for protections when infringement occurs. Infringement is just a fancy legal word that means unauthorized use. Someone is using your trademark. You can have copyright infringement, you can have patent infringement. Trademark also includes what is called dilution, and this is an extension, so not just infringement is actionable under the law, but also dilution. Dilution is where someone is using your mark without your permission, but it's causing some sort of tarnishment on your mark. So it's somehow negatively impacting your brand reputation. So it's kind of like an additional type of protection that's afforded for trademark owners. We don't have dilution in copyright law. We don't have dilution in patent law, but we do have that in trademark law. So the website, and I'm not going to show you the website, but I do have the link there at the bottom in case you want to take a look at it. It's uspto.gov. That's the federal agency that takes care of registering trademarks and patents for companies and for individuals. And if you go to the website, you'll see that you're kind of ported into two different sections. One is for trademarks, the other is for patents. In both of these sections, you can do a physical search. So whether you want to search for like an image, like a logo, or if you want to search for a term or a slogan, that's up to you. but you can kind of see the lay of the land, so to speak, in terms of what other individuals have registered through the USPTO. And if you're a new startup, let's say you're creating a new business, you might want to look and see, well, is someone else using this trade name? What do their logos look like? Because the last thing you want is to, whether it's intentional or by accident, infringe on the mark of another, intellectual property owner. So the USPTO is a huge asset in terms of just doing searches. This is also the conduit in which to submit your applications when you are applying for a trademark or a patent. So you can do it all electronically, and it makes it very quick and easy for submission purposes. If you are starting up a new company, and let's say you have this trademarked slogan, logo, distinctive name, you can interact with the USPTO on your own. You don't necessarily need an attorney, but I know a lot of times people are kind of a little risk adverse in terms of they don't want to make a mistake. And so if you want to hire an attorney to assist you with that, that's fine. For trademark registration, any licensed attorney through the state bar is eligible to assist you in that regard. It's pretty much filling out forms, so it isn't that complicated. If you're hiring an attorney to represent you to register a patent, that is a little different because the person who assists you with that has to be a patent attorney. And so patent attorneys pass not only the bar like a regular attorney, but there also is an additional patent bar that they are required to pass. And they also are required to have like a science background in terms of academic education. And so they have kind of like a special kind of like requirement that they have to kind of be certified in. And then they can provide you assistance if you have an invention that you think is new, novel, non-obvious, and that you think is distinctive and new in a particular area of technology. And I'll get more into patents in just a little bit. But USPTO overall, great website, a lot of resources there to assist burgeoning companies as they develop trademarks and or patents. In terms of trademarks, the reason why I like to start off with this is because, this is something that we as consumers have a lot of experience interacting with, even if we don't realize it. And so I just, I picked some of these trademarks here for a couple of different reasons. One is many of them are common brands that we as consumers see almost on a daily basis sometimes. Another reason why I've chosen this is to highlight that a lot of trademarks today have become very distinctive because they incorporate multiple elements in the imagery that you see. So you can see like Baskin-Robbins, for example, the B and the R. You see what's highlighted in pink is part of the B and part of the R, but it also appears to be 31. Baskin-Robbins being known for 31 flavors of ice cream. So it's a very distinctive mark in that as a consumer, you see it, it's ice cream, because we've probably been exposed to it before. And then you also get some descriptiveness, understanding, wow, okay, so they have 31 flavors there. If you look at let's look at Amazon. Amazon is a huge brand right now in terms of, a powerful company and the intellectual property portfolio that they maintain. Amazon has that little smiley face arrow, and you can see when you see it as Amazon, the arrow goes from A to Z, and the idea is that Amazon sells everything under the sun from A to Z. So that, there is a strategy, there is a purpose behind a lot of the marks that you see, even though you may not realize it. If you look at the Bronx Zoo, you can see, obviously, you see some animals there. It looks like a giraffe, maybe a taller giraffe and a less tall giraffe, and then some birds. If you look at the legs of the giraffes, you can see that it kind of outlines some distinctive buildings in the New York City area. And so again, they're adding some uniqueness to their trademark, their brand for the Bronx Zoo. If you look at Tour de France, in terms of like in the tour part, the O and the R, those are part of a bicycle, and so you can see the R is like, part of the squiggly part of the R is like the rider on a bicycle. Tour de France, biking. Let's see, Hope for African Children Initiative. It looks, if you look at it quickly, it looks like the African continent, which obviously, you know, they're a nonprofit, you know, kind of advocating for children's care in Africa. But then if you look a little closer, it does look like on the left-hand side, it's like a child in a lower position, and then a parent, presumably maybe a mother, in the higher position off to the right. And so again, they're incorporating multiple elements there. The reason why I like to highlight this is, one, I find it's very fascinating, and two, it's a great blending of art and business. So, you know, for those of you that are creative and you like to, you know, kind of, you're always thinking of ways to kind of incorporate maybe some artistic expression and blend that with some sort of business activity, this is your line, this is your avenue to kind of, you know, thrive in as a future business professional. Let's see, just a couple more real quick. Tostitos, if you've ever noticed, each T is like two individuals, and then the I, the very dot of the I, is like a bowl of salsa, and so each T is holding like a chip. So, you know, chips and salsa, you know, that's Tostitos. And then lastly, FedEx. If you look at the E and the X at the very end, you see that there's an arrow between those two letters, and it's kind of like, you know, like, yeah, X marks the spot. So in terms of, like, you know, they will deliver anywhere, and so they deliver right where they're supposed to. So, you know, again, just some you know, distinctive things that some very creative marketers and business managers have collaborated with to kind of develop these very distinctive brands and the logos that represent them. This slide here represents how, when you think of like the major corporations, so if we're talking about PepsiCo, Coca-Cola, Nestle, Procter & Gamble, Kraft, Johnson & Johnson, Unilever, all of those sub-brands that come under their umbrella, huge investment in their intellectual property portfolio. So we're literally talking about billions of dollars on this slide in terms of the value of these companies, just in their trademarks and their patents and copyrights. So huge area in terms of burgeoning commercial activity. And the last probably 30 years has been a legacy of trying to maximize intellectual property. And by the time we get to the end of the different types of intellectual property, we'll talk about how they're blending together in like a single product or service, different forms of intellectual property in order to maximize their investment in it. So when we talk about trademarks, we're talking about names, symbols, designs, and there's usually a range of distinctiveness, you know. So, you know, on one end of the spectrum is completely arbitrary or fanciful. And I give the example there of like Kodak film. You know, Kodak is a very unique word as a lexicon. And so, you know, that and all the marks associated with Kodak are very arbitrary, very fanciful. So it's a very strong mark. You go to the other end of the spectrum, this is usually marks that sometimes have a secondary meaning, and, you know, maybe in the marketplace you have acquired some sort of association with that mark. Otherwise, maybe it's just descriptive, or maybe it's just a geographical term. And so I give like Philadelphia cream cheese. So that's a brand of cream cheese. If you or I wanted to start, let's say, Orlando cream cheese, that's fine. You know, as long as our logo is different and it's not like the Philadelphia mark, there's nothing that would prevent that from happening. You know, again, we'd have to invest in the market. We'd have to invest in helping consumers identify our product or service as being kind of unique, so that it would eventually acquire this kind of like secondary meaning in the minds of consumers. But that's something that we could do. The center one is where the mark is suggestive of some type of quality or attribute of the product. And so like Frigidaire is a brand for appliances of like refrigerators and freezers. You know, they kind of blend into the name some sort of hint as to what their product or service is about. So you know, all of these are marks, trademarks. All of these are worthy of protection. It's just the stronger you go in that continuum, the better positioned you are in terms of having a more powerful asset as a company. That's not to say that if you have a mark that has acquired secondary meaning, it cannot be powerful. Think of Apple. You know, Apple computers, you know, it's like, well, Apple is just this generic term for a piece of fruit. But over a period of decades, it has been built into, you know, one of the most powerful brands globally as a computer manufacturer. and also a provider of different other types of electronics, smartphones, and so on. So it is possible for even though maybe it is an average term that is descriptive in nature, if you with enough investment and enough success in the marketplace, it can blow up into something really big. So purely generic terms normally are not going to be trademarked. Apple is an exception. Microsoft Windows is another exception. But normally, if something truly is generic, we are not going to trademark that. So I give an example like soap, car, shirts. Normally, that's not going to be something that you would trademark because the Patent and Trademark Office examiner would look at it and he or she would be like, well, this is just a generic term. I'm not going to, trademark, soap. It's like, well, soap is descriptive of the substance that cleans, clothing or humans, So normally generic is insufficient. If somehow you have been selling your product or service and it's a generic term and you built up in the mind of consumers that there is an association, then maybe now we can make a case to the USPTO that this is worthy of trademark protection. Trademark also includes what's called trade dress, and so that's the actual shape or presentation of the product or service. So imagine going down, let's say, Halloween, is a popular time of the year, fall, and it always makes me think of candy. And candy is something that's a great example for trademark. Because think of all the different types of candies that exist out there. In the world of candy, shape is a big deal. Also, what's another big deal is color. So if I'm getting ready for Halloween and I know that I'm going to have trick-or-treaters and I'm thinking, well, okay, I want to get some peanut butter cups. Peanut butter cups, as many of you probably already know, you're looking for orange and brown wrapping. So it's a quick way if you're scanning the sea of candy on the candy aisle in a grocery store. If you see the orange and brown, you're probably closing in on peanut butter cups. If you're in the mood for, let's say, M&Ms, I think the yellow bags, if I remember correctly, I haven't had M&Ms in years, but let's say peanut M&Ms, I believe those are yellow bags, and so okay, look for yellow bags if you want peanut M&Ms. If you want the peanut butter M&Ms, I think those are kind of orangish. I think I could be wrong. And then if you want original M&Ms, that's usually dark brown, the wrapping with white lettering. So again, color can be used as a way of distinguishing your product from another product. Another example, completely different, and this involves an attribute of a product. If any of you are like motorcycle enthusiasts, Harley Davidson. The muffler system in a Harley Davidson is tuned to a specific frequency. And if you make, let's say, Honda or Kawasaki motorcycles, they are not allowed to use the muffler in terms of the tone that it emits of a Harley Davidson. That would be trademark infringement. So when you hear that distinctive sound, and a motorcycle goes by, you don't even have to see the motorcycle. It's a Harley Davidson. And so as long as it's not an attribute of the product or service itself, if it's something that you can manipulate and make distinctive, then it is subject to being trademarked. So really your creativity is your only limitation when it comes to different types of trademarkable attributes for the product or service that you're selling. If you are a trademark owner and you believe that someone is infringing on your trademark, then your initial, probably contact with the infringer is you're going to send a cease and desist letter. You could say, look, we have a registered trademark. You might want to include the proof of your registration and give an example of what you have discovered they are doing and say this is in violation of the trademark that we own. We do not give you permission to do this. And then you give them, whatever period of time. It could be a week, 2 weeks. After that notice is received by who you think is infringing, then it's up to you at that point. If they continue infringement, then you can always seek litigation against that particular party. Anyway, as a trademark owner, you do have to be very vigilant in going after infringers because your trademark can be lost if you allow other people to use it without permission. So I give some examples there: aspirin, thermos, Pilates, frisbee, cola, cellophane, zipper, yo-yo, trampoline. All of those used to be very well-known trademarks, but because of their success and because of those original companies not going after infringers, those terms have now become generic. So like aspirin, for example. Aspirin just in and of itself is a medication to alleviate headaches or some kind of pain physically with the person's body. So anybody, you or I, could come out with aspirin. So I could come out with McKenzie's aspirin. There's obviously, think of branded aspirin. There's Bayer aspirin, there's Ecotrin aspirin. What makes those products unique as a trademark, like, if it's McKenzie's aspirin, or if it's Ecotrin aspirin or Bayer aspirin, it's the name of the aspirin. That's what makes it trademarkable. Aspirin is just kind of like an afterthought, just like Coca-Cola, Pepsi-Cola. The cola is a generic term for, carbonated beverage. And so, the Coca with cola is distinctive. Cola by itself is generic. I could have McKenzie's cola, so it doesn't matter. But Coca-Cola, Pepsi-Cola together, now we've got a game, in terms of having a valuable trademark. Something that we've been seeing in recent years, I've seen it. I don't know if the author doesn't really talk about this, but I've seen in like journals, they're referred to as zombie brands. And so this is where you see maybe a product that has been abandoned. Maybe it was originally abandoned just because it went out of business, or consumers lost interest in the product or service. And then years later, usually out of nostalgia, there's a resurgence or interest in this particular product or service. And so hence the name zombie brand, like it comes back to life. And so some examples there: Nuprin, another pain reliever; Atari, Burger Chef, Amiga, the computer company. Those are all instances of companies that have tried to do a comeback, and so try to bring new life into the trademarks that they had developed from years before. So marks, as I mentioned at the beginning of our discussion today, do represent a significant asset for a lot of major corporations. Coca-Cola, their trademarks are valued at over $78 billion. Google is actually it's more than $44 billion today. Apple, $29.5 billion, and so on. And so just their trademarks alone, they can borrow against it, they can sell it, they can license it. There's so many things that you can do because it functions as property, even though it's intangible. Xerox is a great example of a company over the years that has been very fearful of losing its trademark rights in Xerox, that trademark, the name of their brand. And I think, when you think of modern digital technology, maybe it's less impacting today, but back, like I remember when I started practicing, it's still what was still very popular was photocopying a lot of documents as opposed to scanning or making PDFs. And so, someone would, you would hand someone some documents, and, the appropriate thing is to say, please photocopy these. And so make, copies. But what I've seen, and I'm sure maybe you all, if you're old enough, you have seen, is that sometimes people would hand documents to someone and say, can you go Xerox these? And when you say Xerox, what you mean is photocopy. But in your mind, you have associated Xerox as a noun. You're now treating it like a verb. And I know that may seem kind of like, semantics, in terms of like the English language, but that's that pathway that you start to go down. If the trademark is now being used as a verb sense, so it's the thing that you're doing, then all of a sudden you run the risk of that becoming generic. And the last thing Xerox wants, at least historically, is for its brand to become generic, because if it's generic, anybody can use it then. So let's say it's Canon, a competitor of Xerox. Canon could say, come Xerox on our photocopiers, and it's like, if you're a consumer, you're going to be confused initially, until you realize, oh, okay, Xerox just means the photocopy. It's just a fancy word for photocopy. Google right now it's very interesting in recent years in terms of Google and Microsoft in terms of the search engine war that's going on. And so, Microsoft has Bing, for those of you that like to search using the Bing search engine, or, probably more popular or more well-known is the Google search engine. So Google makes no bones about it. They advertise, on social media, they advertise on television, they advertise on the internet. When you need to look for something, just Google it. And so they are using their trademark in their own way as a verb. And so I think I get the short-term strategy of that. I mean, I think they're trying to win the search engine war, but they do run the risk of having Google become a term that means to just search on the internet. If Google becomes generic as a term, then Microsoft could capitalize on that, and they could say Microsoft could have a promotional campaign and say, "Come Google on Bing." And if Bing becomes generic, Google could do the same thing. Google could say, "Come Bing on Google." And then at that point, consumers are like, "I don't even know what's going on anymore. This is too confusing." So there is an underlying concern for trademark owners. It's like you build a lot of value in your brands over time, and you don't want to lose that. And so that's why you do need to be very vigilant in trying to protect your intellectual property rights. I won't play the Ben & Jerry's lawsuit, but it's a fascinating case involving dilution. And so Ben & Jerry's, popular ice cream company, another company not known for ice cream, known for something very different, was trying to use Ben & Jerry's style logos and their distinctive trademarks to sell a totally different type of product and service than what Ben & Jerry's normally sells. It's an interesting video, and so if you have time, I recommend you watch it. But I don't I don't have time to show it to you in this venue. But a very fascinating case. Ben & Jerry's does prevail at the end, just as like a spoiler alert. But interesting case nonetheless. Copyrights. So shifting to the next type of intellectual property that we're covering today. This is the right, exclusive right given under federal statute to the creator of a literary or artistic work to use, reproduce, or display the work. So trademarks, I didn't mention, once you have a trademark licensed or authorized by the USPTO, it's valid for 10 years. And then after 10 years, you need to renew it. So government always gets its cut, of money. So you got to file the refiling fees, and then you have your trademark for another 10 years. And as long as you're in business, and as long as you're using your marks, and as long as the U.S. government still exists, trademarks can go on forever. Coca-Cola, for example, has been around over a century. And so, they're one of the longest, not the longest, but one of the longest kind of running trademark that does exist. Copyright, we have a fixed duration for copyright, and it depends on how it is created. So the general rule, it's for the life of the creator plus 70 years. So let's say that I'm 50 years old and I write a song, and so if I die tomorrow, it's like, okay, it's good for 70 years after death. So that would be, we're looking at 2020 plus 70 is at 2090, I think. I'm not very great at math, so you have to apologize. I have to apologize. But let's say 2090. So after 2090, it becomes in the public domain. Public domain means anybody can use it. If I hire someone to write a song, then that's called a work made for hire, and that's valid for 120 years from creation or 95 years from first publication, whichever is shorter. So that's the rule. Whenever I think of copyright, I think of Disney animators. So Disney has a huge team of animators, and they're all doing very distinctive copyrightable work, but they are not getting the credit for the copyright. I mean, their job is to create this copyrighted work, so it's a work made for hire. So Disney is the one that owns all these copyrights. So think of all the animations and all the characters at Disney theme parks and that they've developed over the years. And so as soon as it's created, or 95 years after first publication, that's how long their copyright lasts. So you get a kind of a feel for the window here. Copyrights and patents, interestingly, are both mentioned in the U.S. Constitution. Trademarks and trade secrets are not. And so the founding fathers, they had an idea that, copyrights were expressive in nature, because back then there were songs and there were obviously novels, literary people, painters, artists, sculptures, all this stuff. And they wanted to protect their creative works. And so that's copyright. There also was, primitive as it was, I mean, there were the sciences back in the late 1700s. And so the founding fathers felt that, well, we need to have patent law to protect the creations of the mind, just as if we're talking about the creations of someone's hands, if you're, writing a song or creating a sculpture. And so that's really the idea and the spirit behind, the arts and the sciences being protected through copyrights and patents. Now, once you get past this expiration for copyrights and patents, it goes into what's called the public domain. And so the public domain means that anybody can use it at that point. And so an example that I like to use, think of the classic fairy tales, so like Hansel and Gretel, or Little Red Riding Hood, or think of like characters from like, ancient Rome or Greek mythology, think of, like Hercules. The origin of those characters are public domain. So I could make a movie about Hercules. A studio could make a movie about Hercules. And we're both independent of each other, and we're not infringing on either's copyright, because the original kind of whole storyline, is from hundreds of or thousands of years ago in some instances. So that's what we're talking about when things drop into the public domain. Same thing with patents. When we get to patents, let's say I invent a new medication that's patented, that deals with, I don't know, let's say it cures some kind of disease, cures COVID, So patents normally are 20 years. Once that 20 years expires, anybody can make that medication. They don't need my permission. It's public domain. So that's the kind of like the price that copyright and patent owners must face, is that, at some point it's going to go in the public domain and then they lose control over it. But until that day, they have some pretty powerful rights in what they have. So for copyrights, to get back to that briefly, you have the right to reproduce the work, to prepare derivative works, to distribute copies, to publicly perform the work, to publicly display the work. So I'll stick with Disney because it's something that we all are kind of familiar with here in Central Florida. And think of, the original, like Mickey Mouse, Steamboat Willie, from a century ago. Think of all the different forms of or variations Disney has created, products and merchandising for Mickey Mouse alone, let alone all the other characters, Minnie Mouse and Pluto and Donald Duck and all those characters. It's on backpacks, it's on wallets, it's plush animals, it's computer games, it's movies, it's cartoons, you name it. They have kind of perfected the maximization of value out of a copyright. Disney has done a spectacular job doing that. The fear that Disney has, and it's rightfully so, is that, if Mickey Mouse, the original Mickey Mouse, kind of drops into the public domain, then anybody potentially can pick that up. And, if you're Universal, it's like, well, do you really want Universal to be able to have a Mickey Mouse ride? That could be very problematic. So in recent decades, there has been a push by Disney on Congress to kind of extend the life of copyright. And they've done so a couple of times, but it's not clear if that's going to always be the case going forward. So they're going to have to somehow figure out a different way to protect some of that early, very, very early forms of copyright that they've developed. This is an interesting case. It involves PETA versus Wildlife Personalities Incorporated. And this artist, I think his name's David Naruto. And so he films wildlife. And he gave this one primate, forgive me, I don't know the specific type of animal this is, and gave this animal a camera. And so wanted to see what the animal would do with it. So the animal just takes random photos, But one of the photos that the animal took was a selfie. It was a picture of itself. And the question that kind of ensued, and this is how PETA gets involved, because PETA is a animal kind of like protection society, people for the ethical treatment of animals. They're always looking for ways to establish that animals have rights under the law. Currently, animals, the only rights that they really have is that they're treated like property. So if I cause some kind of harm to another person's animal, then if it, whatever the harm is, it's like I damaged their property, and so that's what I would owe. But if you're looking for some sort of intrinsic value as a species, as a life form, the law hasn't gone that far yet. So anyway, PETA sues on behalf of this monkey and says that this monkey should be the valid owner of this picture that it took. And of course, what they're trying to do is to get a court to recognize that this animal has ownership rights. If an animal has ownership rights, then we're going to equate it equal to human, and so it has human rights or human-like rights. Obviously, the judge was not going to take the bait, for that. And the parties eventually settled, and the photographer agreed to donate some of the proceeds from the money he made from this photo to different animal protection and charities. So interesting case, but again, the law has not come that far enough yet to recognize that animals are anything really more than just property that humans own. So even though, I don't know, I mean, you guys are going to have your own opinions, but if any of you have ever had like a family pet, I've had family pets that our family looks at them as like a member of the family, so it's not just a dog or just a cat. But again, the law has not kind of, the sensibilities of the collective in our legal society has not come to that conclusion yet. In the world of copyrights, this is the last slide that I'll show you in copyrights, there is something called fair use. And the idea with fair use is that, normally we've given copyright owners pretty exclusive control over their creative works, unless we want to try and analyze it maybe in an academic setting. And this is where fair use comes in. So there's a 4-part test that the courts have kind of formulated and developed over the years. They look at the purpose and character of the use of the non-copyright owner. They look at the nature of the work itself, the amount of the work that was used, and the effect on the use. So I'll give an example of a movie. So I didn't show this to you guys, but it's sometimes I show a clip when I have like face-to-face classes from a movie from the 1980s called Wall Street. The main star in it is Michael Douglas. Great actor, great movie. The movie is all about corporate greed on Wall Street in the 1980s. And so there's a scene in this movie, it's about 2.5 minutes. It's like a soliloquy. Michael Douglas's character is kind of like the villain in the movie. And so he's talking to a group of investors, and he's talking about how greed is a good thing. And sometimes it's called the greed is good speech. And so he's going on and on about how greed is good. Greed for money, greed for love, greed for life, greed for anything. It's what propels human endeavor into the future, and it makes us take risks, and with the hope of a reward of some kind. And so in ethics, when we cover the ethics chapter, that would be a great kind of clip to show you, and to say, let's discuss this. Is greed really a good thing? Or is it a bad thing in society? If I were to show you that 2-minute clip, I don't need to get permission from the studio that owns the copyright, because the movie is still copyrighted, because it's from the 80s, it's not that long ago. So it's a classroom environment. I'm showing just 2 minutes of it. I don't need anybody's permission. I can just show the clip to class, and then we can discuss. Okay, change the facts a little bit. Let's say that I want to show the entire movie, and as students come into class, let's say I charge $5 to come in and watch the movie. I make some homemade t-shirts that say greed is good. Maybe I don't know, I sell other merchandise. Now this is not really an academic thing anymore. It's more of a commercial thing, and the copyright owner is going to want control over that. They're going to either say, yes, this is okay, give us our money, or no, this is not okay. You're somehow, you're using our copyright in a way that we did not want you to use. So fair use is fairly narrow in nature. If it's for an academic purpose and you're only using a small portion of the copyrighted work, you're protected. If it ends up becoming like an income stream and you're using all of the work, that's a little different. You're going to have less of a legal position to kind of defend that this is fair use. Okay, patents. A patent gives an inventor an exclusive right for 20 years from the date of application to make, use, or sell an invention, and it has to be new, it has to be useful, and it has to be unique or not obvious. And so there are utility patents. That's, like a new useful process, machine, manufacture, composition. It could be a design patent. So that, this is like new, not obvious ornamental features. And then there are plant patents that deal with varieties of like different types of plants. Under the America Invents Act, the effective filing date is the actual filing date, not the date of invention. So it's like a race to whoever files first. That's when we start ticking the time clock for who's first in line to get a patent. Because sometimes there are people who think of things in similar time windows, and it's like who registered it first or who applied first, and then as soon as they get the patent, it goes back to the actual filing date, not the date of the invention. So you can sit on it for a while, but you have to be careful. If you sit on it and then someone else files before you do, it's like, well, we're not looking at the date of invention then. So if you do have an invention, best advice is to kind of get on with it and file a patent for it so that you're ensured protection. In order to receive a patent, as I said, it has to be new, not obvious. Historically, a lot of people have thought of patents as like mechanical things, like, okay, I'm going to improve the carburetor. I invented a new drug to treat a disease. And those are, for forever, it seemed like that was the standard that most people associated with something that's patentable. Beginning in the 80s, though, there was this case called Diamond v. Chakrabarty, and I don't have you guys read this case, but if you're ever curious, it's an interesting case to read. One of the legacies of that case is that the Supreme Court said that anything under the sun made by man, and mankind or humans, is subject to patentability potentially. So years later, so we have this opinion, so it's not anything under the sun, basically. Years later, Amazon, they kind of come into being, and if any of you have ever purchased things from Amazon, we know today you can set up a profile and they have what's called a one-click purchasing system. That actually is a computer program, and it's fairly simple. I mean, you set up a credit card, you set up a delivery method, you set up a delivery address, and then as you're surfing through Amazon, you can just one-click on stuff and it auto orders. It doesn't go to a checkout register and then you later have to check out, and actually order it. It just auto orders if you set it up that way. No one had ever done that before, and so Amazon had the foresight of let's apply for a patent. This is something that's new, it's unique, it's not obvious, and they have a patent on that one-click technology. So if you're on a non-Amazon site and you're doing one click, they either have licensed it, from Amazon to have that ability, or they're infringing on Amazon's patent. So there was another patent, and I think this was in the Diamond v. Chakrabarty case. It was like some algae that I think was formulated to kind of break down a specific type of hazardous waste. And the patent examiner said, well, you can't patent algae, because that's a life form. And the patent examiner is correct. We can't patent life forms, but what was being patented was how the algae was modified so that it would eat toxic waste. And that is what is patentable, is that kind of add-on, even though the underlying base is a life form. So anyway, the last slide that I have for this chapter involves trade secrets. And so trade secrets come up in almost any industry. If you're a restaurant, your recipe could be a trade secret. If you're Coca-Cola, their formula, if you've ever been to the Coca-Cola plant in Atlanta, their headquarters, they have a big part of their, tour is, showing you the vault where allegedly the formula or the recipe for Coca-Cola is kind of, enshrined. And so it could be customer list if you're a salesperson. There's all different ways in which you can have trade secret information. The key thing is that there's no federal law that protects trade secrets. This is all done under state law. And usually what state law requires of trade secret holders is you have to, be very vigilant in protecting this as a trade secret. So limit access. Not everybody should be able to see what the secret is in your organization. If you do hire workers, make sure they sign NDAs, which are non-disclosure agreements. If you see examples where employees are trying to reveal information that is a trade secret, you got to come down on them hard. Fire them, sue them, whatever you have to do. You have to be very vigilant. As employees leave your business, and if they came in contact with trade secrets, conduct exit interviews and make sure they understand that even though they may never, come back to your employee, they can never share that information with future employers because it's a secret. And there are some criminal statutes that have been kind of applied for, if you were involved in some sort of like corporate or economic espionage. That seems to be less common, but it is theoretically possible. But normally trade secrets, it's a state thing. And so, even though these are, global corporations down to mom and pop shops, you've got to take proactive efforts in order to keep information secret. And if you do that, then that will give you a superior kind of leverage if you end up litigating a case against an employee or someone who's trying to deal with whatever the information is that you're trying to hold as a trade secret. Anyway, that's it for Chapter 32. I hope this brief lecture has given you a little bit more insight into intellectual property. It's a fascinating area of business, because it really is kind of a synthesis of business principles, legal principles, and then, science or maybe artistic expression. And so there's a lot of things that kind of come together. One final thing, and I briefly mentioned this at the beginning, is that, the general trend is to try and fold into a single product patents, trademarks, copyrights, trade secrets. So there are some pharmaceutical companies, as an example. If any of you take prescription medications, usually like the color of a pill is random. A pill doesn't have to be pink or yellow or blue or white. That's something that's distinctive. So the color of a pill, that can be trademarkable. The copyright or the shape of the pill, that can be something, again, when you think of, if you're designing something, pills, why are some pills circular? Why are some oval? Why are some square or triangular? That's a copyrighted feature. Obviously, whatever the medication is, you think of like the chemical compound, that could be the patented portion of it. And then the trade secret could be, sometimes how you mix together ingredients. Even though you have a listing of what the ingredients are, you may not necessarily know how they're kind of combined or put together in terms of the final product. And so that could be the trade secret part of it. So in one like pharmaceutical pill, you could have trademark rights, copyright rights, patent rights, and trade secret rights. And that seems to be a trend. Companies are like, they want to squeeze every, last little ounce of what they can of juice, so to speak, out of all of these products and services that they offer. Anyway, if you have questions, please feel free to message me anytime. Otherwise, I hope everyone has a very good, safe, and productive week, and I'll be chatting with you all online. Thank you.